Namaskar and good evening to all. On behalf of Akhil Bhartiya Adhivakta Parishad Devgiri Prant, I once again warmly welcome all of you to the fifth lecture of Shri Sandeep Munde sir in this series of District Judge and JMFC Civil Judge Junior Division Examination Preparation. As this is fifth lecture, sir hardly needs any formal introduction. His clear structured and exam-oriented teaching, coupled with practical illustrations, has consistently made even the most complex aspect of the law easy and engaging. At the outset, I sincerely thank Sir for sparing his valuable time despite his busy schedule and for his continued guidance in this series. I also appreciate the consistent participation of all the aspirants, which reflects your dedication toward the examination. I am confident that today's session will further strengthen our understanding. With this, I invite Sir to kindly begin today's lecture. Thank you.
Thank you, sir. Dear friends, in the last session or in the last 4 lectures, we have discussing the provisions about the Code of Civil Procedure. So first at all, in the first part, we have taken the introduction of the Code of Civil Procedure. Then after we discuss the place of suing or the jurisdiction aspect from section 9, where to file the suits. Then after we started with the order 1, that is the parties to suit, and lastly we concluded with the order 20, that is with regards to the judgment and decree. So for our convenience, our first part of the Code of Civil Procedure from the institution of the suit up to the passing of judgment and decree has been completed. Now, what is the next stage after the passing of the judgment and decree? We will discuss. So firstly, when we have to discuss the concept with regards to the what are the stages after the passing of judgment and decree. So first at all, when the parties approaches to the court, when there is any illegal things, there is the encroachment of their rights, then when the party approaches to the court will pass the judgment and decree according to the order 20, that is the judgment and decree. The person in whose favor judgment or the decree will be passed, he will be a person decree holder or the person who is capable of made the order execution. So the person who in whose favor judgment or the decree or the order has been passed, he may go for the execution, and the second party against whom the judgment or the decree or the order has been passed. So he will be treated as a judgment debtor. So after order 20, again, there will be the 2 routes available with the parties. One route, that is the from section 36 to 74, which deals with regards to the execution of proceeding, along with the longest order of the Code of Civil Procedure, that is order 21 of the Code of Civil Procedure, which deals with regards to the execution of judgment and decree. And the person against whom the order or the decree has been passed, he will go with the appeal, that the provisions of appeal will start from section 96 and order 41. So in today's lecture, we will discuss the provisions with regards to the execution proceeding, that is the basic thing with regards to the execution of judgment and decree. So when the party in whose favor order or the decree or the judgment has been passed, he will automatically get the fruits of that decree, or certain procedure is required to execute that judgment or the decree. So the part 2 of the Code of Civil Procedure deals with regards to the execution, in which from the major portion of the sections also covered from section 36 to 74. If we divide that portion or the part second of the execution in the section part, it will cover near about 10 subheadings under the execution proceedings. And the same thing with regards to the order 21, in which the longest order of this code of civil procedure, in which the total 106 rules are there in the order 21. So there are the common headings in between section part and the order part in the code of civil procedure. So first at all, we will discuss what is the meaning of execution proceeding. Or if we have discussed earlier in the definition of execution, or there is no definition of execution in section 2 of the code of civil procedure. So what is the meaning and what is the importance of execution under the code of civil procedure? So execution means the process for enforcing or giving effect to the judgment of the court. So what is the meaning in the simple terms? It is the process for enforcing or giving effect to the judgment of the court, or in the other words, execution is the enforcement of decrees and orders by the process of courts. So for what purpose? So as to enable the decree holder to realize the fruits of the decree. Only the passing of the decree on the paper, the decree holder or the person in whose favor orders has been passed will not get the fruits of the decree unless and until he got that decree executed. If the fruits of that decree has been realized, only on that count the process of the execution will be completed. The execution is complete when the judgment creditor or the decree holder gets money or other things awarded to him by the judgment, decree, or order. So, if any decree has been passed, the decree, if we take the example, the decree with regards to the money, there was the two parties, Sakha and Tuka, and if the suit has been decreed that Sakha has to pay rupees 5 lakhs to the Tuka, unless and until he pays that amount to the Tukara. When he not paid that amount, what is the option available with the Tukaram? Tukaram will file the execution petition before the competent court of law to execute that judgment or the decree. So then what the questions will arise is to discuss the provisions with regards to the execution of decrees and orders. The first question with regards to the which courts are competent to execute the decrees, which courts are having jurisdiction to decide the execution application. Second question, who may apply for execution? Third question, against whom the execution proceeding will lie. Fourth question, whether the decree can be executed or the any other person other than decree holder may apply for the execution of decree, that is the concept of transferees and legal representative. Then the process with regard to the procedure in execution, what is the procedure in execution needs to be followed. At the same time, as like the suit, whether it is necessary, whether it is mandatory to issuance of process to the opposite parties, yes, I am going to file the execution proceeding and it is against you, whether in which circumstances issuance of notices are required. If the parties is not ready to execute the decree against him, the provisions with regards to the arrest and detention are also there. Provisions with regards to the attachment of the properties are there. If we have to attach the properties, property are of two kinds, movable property, immovable property. Whether only by attaching the property can the decree be got satisfied? No. For that purpose, again the stage will come with regards to the sale of the property. Then again the procedure with regards to the sale of movable property, sale of immovable property. Again, the thing is that if during pendency of the execution proceeding, if any question arises for determination by the executing court, which court is competent to decide that question? So, all the questions to be determined by the court, executing decree, section 47, and rule 58, adjudication of claims and the objection. After doing all these things, if there is the resistance to delivery of the possession to the decree holder or purchaser, what recourse is available with the concerned party? Or if any third party wants to raise the objection, under which provisions or under which rule of 21, he may raise that objection. So, as like resistance to the execution and the distribution of assets, section 73, when there is more than one party who is capable or in whose favor decree has been passed, under which capacity he may got the decree, what is the concept of distribution of assets. So I have prepared one chart to show in simple how to get a detailed knowledge with regards to the execution of proceeding. If you peruse this chart contains the entire subheadings which are there under the Code of Civil Procedure dealing with the execution proceeding. First at all, I have made the table in the one chart giving both the rules as well as the section part. From the section part, it is from section 36 to 74, and in the order part, it is from rule 1 to 106. Some of the subheadings are common in both the things, and some are not there in common, but all are the proceedings with regards to the execution of proceeding. So first at all, section 36 is in general in nature, that is the general section 36, which states with regards to the execution and general. Section 36 reads application to orders. Whatever the application of this, it is applicable to orders. Section 37 states definition of court which passed the decree. The expression court which passed a decree or words to that effect shall in relation to the execution of decree, unless there is anything repugnant in the subject or context, be deemed to include. The court which passed the decree means the court which have decided the suit and passed the final judgment and the decree according to the section 20. Now, the next thing, that is the second heading under the section part, that courts by which decrees may be executed in section 38 to 46. It deals with regards to the courts which are competent to execute the decrees. And in the rule part, what is the second heading? Court executing decrees. Meaning thereby, the subheading 2 of section part and subheading 2 of rule part, both are same, both give which courts are competent to execute the decrees. Section 38 reads, courts by which decrees may be executed. A decree may be executed either by the court which passed it. The court which passed the decree is competent to execute it, or by the court to which it is sent for execution. Only two courts are competent to execute the decree. The first court is the court which passed the decree, and second one is it they send it for the another court competent, the court to which it is sent for execution. If there is the transfer of the decree from one court to another court, that court will get the jurisdiction to execute the decree. So the section 39, the transfer of decree. 43, 44, section 46 is the important section with regards to the precepts. So this concept has always been asked in the examination. So what is the section 46? Section 46 states, upon the application of the decree holder, the court which passed the decree may, whenever it thinks fit, issue a precept to any other court which would be competent to execute such decree to attach any property belonging to the judgment debtor and specified in the precept, the court to which the precept is sent shall proceed to attach the property in the manner prescribed in regard to the attachment of the property in the execution of decree, and that no attachment under the precept shall continue for more than 2 months. You have to keep in mind, if there is the concept of precept, one court to attach the property of the judgment debtor which is situated in the jurisdiction of another court may issue the precept, and that the validity of that order will remain for not later than 2 months, only the 2 months validity with regards to the precept, which is under 46 of the Code of Civil Procedure. If we turn to the Order 21, Rule 3 to 9, what it states, courts executing decrees. Which courts is having jurisdiction to execute the decree? That the land situate in more than one jurisdiction, transfer to court of small causes, and the mode of transfer. So, which court, as per this, section 38 to 46 and rule 3 to 9, which courts are competent to execute the decrees? The court which passed the decree and the court to whom the decree has been sent for execution. These two courts are competent jurisdiction to execute the decree and the order. Now, in the rule part, the third column with regards to the application for execution, rule 10 to 23, and hearing of application, rule 105 to 106. Merely after passing of the decree and the order, whether the decree holder will get the fruits of that decree automatically or according to these rules and according to the judgments passed by the Supreme Court, there are two judgments which are contrary to each other. One judgment has been stated, after passing of the judgment and decree, it is for the decree holder to apply to file the execution application within a time stipulated by the law, and he will take the efforts to get the fruits of that decree. Another view of the Supreme Court on the said aspect is that it is upon the court that merely by the passing the paper decrees will not get the justice to the people. After passing of the decrees, the court should look into whether the decree got executed or not. So there are the conflicting views with regards to the execution of decrees, whether the application is required or not. But we have to discuss with regards to the rule 10 to 23 with regards to the application for execution. So, who may file the application for execution? Where the holder of a decree desires to execute it, he shall apply to the court which passed the decree or to the office appointed. So, the person who is the decree holder, he may file the execution application. That the first kind is the oral application. If the decree is for the payment of money, he may file the oral application according to the rule 11. And the second one is the written application, and entire details which we have discussed, which we have mentioned in the suit, in the decree, all the necessary to be mentioned in the written application. Rule 11 sub rule 2 states about the written application, in which it is required to be mentioned the number of suit, the name of parties, the date of decrees, whatever, and appeal, whether the appeal has been preferred or not. It depends when the money, it is the decree of payment, how much amount is there, if it is the decree for the movable property, immovable property, or for the removal of encroachment, all the things are required to be mentioned in the said application. So, after the application has been filed, according to the rule 23, procedure after issue of notice. Where the person to whom notice is issued under rule 22 does not appear or does not show cause to the satisfaction of the court, why the decree should not be executed, court shall order the decree to be executed. So, when according to the rule 22, in which circumstances notice to show cause against the execution is required. If the execution application has been filed more than 2 years, or if the decree wants to be executed against the legal representative, in such circumstances, it is required to give the notice to the concerned legal representatives or the judgment debtors. So, the part fourth of the rule part, that the process of execution, rule 24 to 25. When the preliminary measures required by the foregoing rules have been taken, the court shall, unless it sees cause to the contrary, issue its process for the execution of the decree and order, and endorsement on process according to the section rule 24 and 25. It is required to give the process for execution. This next subheading, stay of execution, rule 26 to 29. Under which circumstances court may grant stay to the execution. As in the appeal part, if the decree has been challenged before the appellate court has a power to stay the execution. Whether the executing court have a power to stay of execution according to the rule 26, when court may stay execution. The court which a decree is sent for execution shall, upon sufficient cause is being shown. What is required? He may show the sufficient cause, stay the execution of such decree for the reasonable time to enable the judgment debtor to apply to the court by which the decree was passed, or to any court having appellate jurisdiction. So therefore, during the appeal period, court will not execute the decree. Court will stay its decree for the appeal period, and then after court will start the proceeding with regards to the same. If the court is going to stay the execution proceeding, court will impose the conditions. Liability of judgment debtor discharge, stay of execution pending suit between decree holder and judgment debtor. If such kind of suit is pending, then in such circumstances also court will grant stay to the execution. Now, the next thing in this, firstly, we will discuss the concept of transferees and legal representatives, who may be called as the transferees and the legal representatives. So according to the section 49, every transferee of a decree shall hold the same subject to the equities, if any, which the judgment debtor might have enforced against the original decree holder. Transferee means the person in whose favor the decree has been transferred. So he will got the entire rights. He will apply the shoes of the decree holder, and the transferee will keep his legs into the shoes of the decree holder, and he will get the entire rights of the decree holder. The concept of the legal representative, that as we are popularly known as LRs. So, if where a judgment debtor dies before the decree has been fully satisfied, the holder of the decree may apply to the court which passed it to execute the same against the legal representatives, and the legal representatives of the judgment debtor are liable to satisfy the decree only to the extent that what they have got from their earlier judgment debtor. Now, the next subheading, that is serial number 5 from section 51 to 54, which deals with regards to the procedure in execution. So, section 51 deals with regards to the procedure in execution. It is the basic or the very important section in the execution proceeding, which deals with regards to the how to execute the decrees, what is the proper procedure for execution of decree and the order. Section 51, I will read the important part. Power of court to enforce execution. Section 51. Subject to such conditions and limitations as may be prescribed, the court may, on the application of the decree holder, order execution of decrees. How? A. By delivery of any property specifically decreed. The first mode of execution is by delivery of property specifically decreed. B. By attachment and sale, or by sale without attachment of property. Second mode is by attachment of by attachment of the property, by attachment and sale of the property, or by sale without attachment. C. By arrest and detention in prison. How to execute the decree? It is also one of the mode of the execution of the decree, that is by arrest and detention in prison. It's not such a period exceeding the period specified in section 58, where arrest and detention is permissible under that section. The D, by appointing a receiver, by appointment of receiver. Order 40 deals with regards to the appointment of receiver. By appointing the receiver, decree also can be executed. E, in such a other manner as the nature of relief granted may require. Apart from these modes, what is the nature of relief has been granted, on the basis of it, decree can be executed. So, the section 51 is the opening statement with regards to the procedure in execution, which deals with regards to the how to execute the decree. If the decree in such a way that if it is required to deliver the property, then by delivery of any property. If it is required to be attachment and the sale, by attaching and sale of that property, or it is in such a way that we sell without the attachment. It can be executed by way of arrest and detention. How to arrest and detain to the civil prison? Provisions has been given from section 55 to 59 and rule 37 to 40. Provisions with regards to the attachment of the property give in section 60 to 64. How to make the sale? Provisions has been given from 65 to 67 and from 64 to 96. So, from the filing of the application, that is the execution application, after the satisfaction of decree, whatever the procedure is required, entire procedure has been given in this section and these rules. So, section 54(2) deals with regards to the enforcement of decree against legal representatives. It can be executed only to the extent of what the property they have got. 53, liability of the ancestral property, and 54, partition of estate or separation of share. When the suit is for the partition of the property, then according to the section 54, where the decree is for the partition of an undivided estate assessed to the payment of revenue to the government, or for the separate possession of share of such an estate, the partition of the estate or the separation of the share shall be made by the collector. Why I read this section 54? If there is the partition and the revenue collection is required, then the court, executing court, will send the decree to the execution to the collector for the execution under section 54 of the Code of Civil Procedure. So, along with these provisions of section 51 to 54, mode of execution deals from rule 30 to 36. Mode of execution, rule 30 to 36, and payment under decree, rule 1 and 2. When there is a decree for the payment of money, what the rule 1 and 2 states? Rule 1 and 2 of the order 21 deals with regards to the payment under decree. Modes of paying money under decree and payment out of the court to decree holder. If it is the decree for payment of money, it can be by depositing into the court, or by handing over the money to the concerned party, it can be executed. Again, rule 30 states with regards to the decree for payment of money, decree for specific movable property, decree for specific performance of the restitution of conjugal rights or for an injunction, discretion of court in executing decrees for the restitution of conjugal rights, decree for execution of document or endorsement of the negotiable instrument, decree for immovable property, decree for delivery of immovable property when in occupancy of the tenant. So, from rule 30 to 36, the nature of relief granted, whatever the property has been depends, what the relief has been granted by the court, whether it deals with regards to the restitution of conjugal right, specific performance of contract or for the movable property or for the immovable property, what recourse has to be followed, that has been given in rule 30 to 36. Now we will discuss the next mode of execution, that is the arrest and detention, section 55 to 59. So what is the section 55? Section 55 heading is that arrest and detention. It is the rule under the Code of Civil Procedure. If you have to arrest any judgment debtor, he cannot be arrested, be brought, whatever he is required to be. Firstly, that the purpose of making an arrest under this section, no dwelling house shall be entered after sunset, before sunrise. In this part of the arrest and detention, the major or the important section is section 58, detention and release. So the section 55 deals with regards to the arrest and detention. 56 states the prohibition of arrest or detention of women in execution of decree for payment of money. If the decree for payment of money, no woman can be arrested in the execution. 57 subsistence allowances. The person on whose behalf application has been made to, he may be arrested and detained in the civil prison. He is required to pay the subsistence allowance under section 57, and that scale of that has been decided by the state government. 58 states detention and release. Every person detained in the civil prison in execution of decree shall be so detained. It is in three parts. A, where the decree for payment of sum of money exceeding 5,000 rupees for a period not exceeding 3 months. Maximum period of detention is of 3 months when the decree exceeds the amount of rupees 5,000. Second, when the sum of money exceeding 2,000 rupees but not exceeding 5,000 rupees for the period not exceeding 6 weeks. And the third part is that if the period shall be released from such detention, if it is in the given in the explanation, if it is less than 2,000 rupees, he cannot be arrested and detained. For the removal of doubt, it is hereby declared that no order for the detention of the judgment debtor in civil prison in execution of decree for the payment of money shall be made where total amount of the decree does not exceed 2,000 rupees. So according to the section 58, there are three parts. If the amount is more than 5,000 rupees, detention not more than 3 months. If amount is between more than 2,000 and below 5,000, it should be not exceeding 6 weeks. And if the amount is less than 2,000, no detention is permissible according to the section 58. And the section 59 deals with regards to the release on the ground of illness. If any such a person has been arrested and if due to the corona or the plague or any such kind of diseases, or he may have his personal disease, he may be released, and whatever period he has been undergone will be minus, and if subsequently he is fit, he may be detained in the prison, but not exceeding the period mentioned in section 58. The similar provisions under Rule 37 to 40 with regards to the arrest and detention. 37, discretionary power to permit judgment debtor to show cause against the detention in prison. It is a discretionary power vested with the court that he may be given show cause if you are not complying the decree, why you should not be committed to the prison. Warrant for arrest to direct judgment debtor to be brought up. Subsistence allowance 39. 40, procedure on appearance of judgment debtor in obedience of the notice after arrest. If he appear and if he fulfill the decree, then court will not ask him to go for the prison. Now, we will firstly come to the subheading 3, questions to be determined by the court executing decrees under section 47. So, the section 57 and Rule 58 and 59 deals with regards to the questions to be determined as well as adjudication of claims and the objection. So the wording of section 47 is that questions to be determined by court executing decrees. All questions arising between the parties to the suit in which the decree was passed or their representatives and relating to the execution, discharges, or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. Therefore, while discussing the section 12, there is the bar to the suit in which we have taken the example of section 47.1. It is precluded to filing of the fresh or there is bar to file the separate suit if all questions, any question arises with regards to their representatives, whatever with regards to the relating to the execution, discharge, or satisfaction of the decree, it is required to be shall be determined by the court executing the decree and not by a separate suit. Where the question arises as to whether any person is or is not the representative of a party, such a question shall, for the purpose of this section, be determined by the court. So, once the execution proceeding has been filed and any question with regard to the right, title, interest, or any of these things has been arises, all such a questions has to be determined by the court, which before the court where the execution proceeding is pending, and for that purpose, no separate suit will lie. So the section 47 and rule 58 and 59. So what is the rule 58 subheading is that adjudication of claims and objections. Adjudication of claims to or objection to attachment of the property. If any dispute with regards to the attachment of the property, any claim or objection has been made with regards to the attachment of the property, it is required to be decided by the same court and no separate suit will. Rule 59 deals with regards to the stay of sale, where before the claim was preferred or objection was made, property attached had already been advertised for sale, the court may grant the stay to the sale to avoid the further complications with regards to it. So, section 47 and rule 58 and 59 deals with regards to the powers of the executing court if any question or any objection or any claim has been arises has to be decided by the same court. Now, next mode of attachment is section 60 to 64. Attachment. Section 60 attachment, property liable to attachment and sale in execution of decrees. Kindly read carefully the section 60 that which properties are liable for attachment. The following properties liable to attachment and sale in execution of a decree, namely lands, houses or other buildings, goods, money, banknotes, checks, bills of exchange, hundis, promissory notes, government securities, bonds or other securities for money, debt, shares in corporation, and save as hereinafter mentioned, or other saleable property, movable or immovable, belonging to the judgment debtor, or over which or the profits of which he has been disposing power, which he may exercise for his own benefit, whether same be held in the name of judgment debtor or by another person in trust for him or on his behalf. These are the some of the properties which are liable for attachment. Provided that the following particulars shall not be liable to attachment or sale, namely necessary wearing apparels, cooking vessels, beds and beddings of the judgment debtor, his wife, children, tools of artisans, and where the judgment debtor is an agriculturalist, his implements of husbandry and such cattle and the seed grains, houses and other buildings with the materials of the sites thereof and the land immediately apparent thereto, books of account, a mere right to sue for damages. You cannot attach mere right to sue for damage. Any right of personal service, stipends and the gratuities, the wages of laborers, the salary to the extent of first 1,000 rupees and 2/3 of the remainder in execution of decree other than for the maintenance the portions of the sum of the salaries, allowances, expectancy of the succession, right to future maintenance, allowance declared by the Indian law, judgment debtor is the person liable for the land revenue. These are the some of the properties of the some of the things which are not liable for the attachment. Section 61 states partial exemption of agricultural produce, partial exemption has been given. 62 seizure of property in the dwelling house. 63 property attached in execution of decrees of several courts. When the several courts has been attached the same property, what is the procedure which has been given under 63? And 64 private alienation of property after attachment to be void. If the property has been attached by the court in the execution of decree, and if he has aliened that property, it will be void. And where the attachment of has been made, any private transfer or delivery of any property attached or of any interest therein, any payment to the judgment debtor of any debt, dividend or other money contrary to such attachment shall be void as against all claims enforceable under that attachment, that is void since beginning in view of section 64 of the Code of Civil. The rules with regards to the attachment of the property has been given under the Code of Civil Procedure from Rule 41 to 57. I have prepared one simple chart to understood the said rules, what is the type of the property and what are the modes of attachment of the said property. If we peruse the rule 41 of the order 21, it states with regards to the examination of judgment debtor as to his property. Which property he belongs to, identification of their property, court may examine the judgment debtor. 42. Attachment in case of a decree for rent or means profits or other matter amount to which to be subsequently determined. If there is the property of rent or the means profit decree, it is required to be adjudicated thereupon. In such circumstances, 42 will help to ascertain after the attachment. Rule 43, movable property other than agricultural produce in the possession. So, in this rule, which rule, the type of property and mode of attachment has been given, I will share this PDF to the concerns. So, if that is the movable property, what is the mode of attachment? By actual seizure thereof, but if such property is perishable or the expenses of keeping it is likely to exceed its value, it may be sold without attachment. 43A, movable property consisting of livestock, agricultural implements or other artisans which cannot be conveniently be attached by leaving the same in the custody of a respectable person as a custodian. So, these are the descriptions of the properties and these are the modes of attachment available from Rule 41 to 57 rule type of property and mode of attachment. If it is the immovable property, by an order prohibiting the judgment debtor from transferring or charging it in any manner and all persons from taking any benefit from such transfer of the charge. Rule 44 and 45 deals with regards to the agricultural produces. 53 deals the decree for payment of money. 52 property in custody of the court or the public officer. 49 and 50 when the property belongs to the partnership property. 48 and 48 is salary or allowances of a public servant or a private employee. 47 share in the interest in the movable property belonging to the judgment debtor and another co-owners. 46B share in the capital of a corporation by an order prohibiting the person in whose name this share stands from the transferring it or receiving dividends thereto. So this is the very short and simple chart which covers the modes of attachment of the property from rule 41 to 57. After the attachment of the property, the next thing that is section 65 to 67 which deals with regards to the sale. So section 65 states with regards to the purchaser's title. if the property has been purchased in the execution proceeding, what is the procedure for the sale of the property? That we have to discuss in the rule part in the three parts. That is the sale generally, sale of movable property, and sale of immovable property. So the section 65 purchaser's title, where immovable property is sold in the execution of a decree and such sale has become absolute, the property shall be deemed to have vested in the purchaser from the time when the property is sold and not from when the sale becomes absolute. The date on which the auction sale has been completed, from that date he will get the title as the purchaser's title as the absolute owner of that property. 67. Power of the state government to make rules as to the sales of lands in execution of decrees for the payment of money. That power is vested with the government. Now we will discuss this rule 64, which deals with regards to the sale generally. When the property has been attached, how to sell the attached property, that the heading is with regards to the sale generally. So section 64, rule 64, power to order property attached to be sold and proceed to be paid person entitled. Those persons who are entitled for the said purposes, the property can be sold. Sales by whom conducted and how made. What is the basic proceedings with regards to the who is competent to conduct the sale and whom the sale has to be conducted and how the sale to be made. Rule 65 states with regards save as otherwise prescribed. Every sale in execution of the decree shall be conducted by an officer of the court. Who is competent to conduct the sale? The officer of the court is competent to conduct the sale, and the court may appoint in this behalf and shall be made by the public auction in the manner prescribed. How to conduct it? By way of public auction. Proclamation of sales by the public auction, rule 66. Modes of making proclamation. Rule 67 deals with regards to how to make what are the modes of execution of proclamation of the sale. Rule 68 deals with regards to the time for sale. It is the time has been given if it is the property of the save as in the case of the property of a kind described in the proviso to rule 43. No sale hereunder shall, without the consent in writing of the judgment debtor, take place until after the expiration of at least 15 days in the case of immovable property and at least 7 days in the case of movable property, calculated from the date on which the copy of proclamation has been fixed. Meaning thereby, rule 68 gives the time for the sale of the property, and it is the time has been given in case of the immovable property, time of 15 days, and in case of the movable property, time of 7 days. 69 gives adjournment or stoppage of the sale. The court may in its discretion adjourn any sale hereunder to a specified day and hour. If the court is found anything, the court has the power for the adjournment or the stoppage of the sale. So, if the sale has been conducted and the person who is required to be deposited the amount, if he fails to deposit the sale, Rule 71 state defaulting purchaser answerable for the loss on resale. If he commits the default, whatever the cost is required will be taken from the defaulting purchaser. 72. Decree holder not to bid or buy property without permission. So, decree holder himself he has not given a permission to participate into the sale. When he obtained the permission from the court, then he may participate. 72A, mortgage not to bid at sale without the leave of the court. Also, the same rule is applicable also to the mortgagee. Restrictions on bidding or purchase by officer, as like the decree holder, mortgagee, the restrictions on bidding on the purchaser by the officers. No officer or other person having any duty to perform in connection with any sale shall either directly or indirectly bid for, acquire, or attempt to acquire any interest on the property sold. Now, from the section 74 to 81, provisions has been given with regards to the sale of movable property. When the property description sale of agricultural produce and it is such a way it is perishable in nature or which cannot be collected, then whatever the provisions of Rule 74, it can be sold. 75 special provisions relating to the growing crops, 76 negotiable instruments and the shares in corporations, 77 public sale by public auction, 78 irregularity not to vitiate sale, but any person injured may sue. If any irregularity has been committed during the said period, he may not vitiate the sale, but if any injured person is there, he may have a right to sue. Transfer of negotiable instrument and share, and 81 vesting order in case of other property. The next from Rule 82 to 96 deals with regards to the sale of immovable property. When the property attaches the immovable property, what procedure is required to be followed in with regards to the immovable property? What court may order sales? Sales of immovable property in execution decree may be ordered by the court by any court other than court of small cause. All courts are competent to order give the order with regards to the sale of immovable property except the small causes. Postponement of sale to enable judgment debtor to raise amount of decree. Deposit by purchasers and resale on default. Time for payment in full of purchase money. Procedure in default of payment. Notification on resale. Bid of co-sharer to have a preference. Application to set aside sale on deposit. Application to set aside sale on ground of irregularity or the fraud. Application by the purchaser to set aside the sale on ground of judgment debtor having no saleable interest. If in the after sale, during the sale process, if it is found that the judgment debtor has no saleable interest in the property, purchaser may apply to the court for refund of his amount as the judgment debtor has no power or the saleable interest in it. Sale when to become absolute or to be set aside, where no application is made under Rule 89, 90 or 91 or where such application is made and disallowed, court shall make an order confirming the sale and thereupon the sale shall become absolute. Return of purchase money in certain cases, certificate to purchaser, delivery of property in occupancy of the judgment debtor, delivery of property in the occupancy of tenant. Now, this is what all the provisions with regards to the sale generally, sale of movable property and the sale of immovable property. Now, only 2 points remain. The section 73 deals with regards to the distribution of assets. So, section 73 proceeds of execution sale to be ratably distributed among decree holder. In which contingencies it is applicable, where assets are held by a court and more persons than one have before the receipt of such assets made an application to the court for the execution of decrees for the payment of money passed against the same judgment debtor and have not obtained satisfaction thereof, the assets after deduction the cost realization shall be ratably distributed among all such persons. If there are more persons than one claiming the same property from the judgment debtor and there was no realization of the said, then all it will be ratably distributed among all such persons. This is provision under section 73 of the Code of Civil Procedure deals with regard to the distribution of assets. Now the last thing in the section 74 and rule 96 to 104. Resistance to execution, resistance to delivery of possession to decree holder or the purchaser. Section 74 states, where the court is satisfied that the holder of a decree for the possession of immovable property or that the purchaser of immovable property sold in execution of a decree has been resisted or obstructed in obtaining the possession of the property by judgment debtor or some other person or some person on his behalf and of such resistance or obstructions was without any just cause, court may, at the instance of the decree holder or purchaser, order the judgment debtor or such other persons to be detained in the civil prison for a term which may extend to 30 days and may further direct that decree holder or purchaser be put into the possession of the property. If any judgment debtor or on behalf of the judgment debtor, any person create the resistance for the execution of the decree, resistance to the execution to deliver the possession, then court may direct he may be detained in the civil prison, but not more than 30 days. So, what are the provisions of 96 to 106? From 97, resistance to delivery of possession to decree holder or purchaser, where the holder of a decree for the possession of immovable property or the purchaser of any such property sold in execution of a decree is resisted or obstructed by any person in obtaining the possession of the property, he may make an application to the court complaining of such resistance or obstructions. He has given power under Rule 97 to file the application. Order after adjudication 98. That 99, disposition by decree holder or possession. Purchaser 100, order to be passed upon application complaining of disposition. 101, questions to be determined by the executing court. Rule 102, rules not applicable to transferee pendent lie during pendency of the execution proceeding or the suit. If he has purchased that property, that rule is not applicable. Orders to be treated as decree. Any adjudication made under Rule 98 or 100, it will be same as like a decree. 104, orders under Rule 101 or Rule 103 to be the subject to the result of pending suit. 105 and 106, hearing of the application and setting aside the order passed, ex parte, etc. So, this is what the execution proceeding. So, in today's session, what we have discussed with regards to the execution proceeding. I will summarize the entire execution proceeding within 5 minutes. First at all, the person in whose favor decree has been passed or order capable of execution has been made, he will go for the execution of proceeding. So, he is required to file the application for execution under Rule 10 to 23. Section 36 with regards to the general provisions. Then the question will be, which courts are competent to execute the decree? You will get the answer from section 38 to 46 and Rule 3 to 9, courts by which decrees may be executed and courts executing decrees. Then there is the concept of transferees and legal representatives under section 59 and 50. Very important section in this part in section 51, procedure in the execution of decree, that how to execute the decree, what are the procedure for execution and what are the modes of execution of decree. By delivery of property, by arrest and detention, by attachment and sale, or by any other mode available as per the relief granted by the court, you may have a power to execute the decree. One of the mode of execution of the decree is the arrest and detention, in which if the judgment debtor is not cooperating for the execution of decree, then there is the decree holder may apply, he may be sent to the civil prison, he has to require to pay the subsistence allowance. Maximum detention is of 3 months if the amount exceeding 5,000 rupees. If the amount is from 2,000 to 5,000, then for not exceeding 6 weeks and less than 2,000, no arrest and detention. No women can be arrested and detained with regards to the execution proceeding. The same rules has been given with regards to the arrest and detention in the civil prison from Rule 37 to 14. Next mode of execution of decree is attachment. What properties are liable for attachment, what properties are not liable for attachment, partial exemption to the agricultural producers. How to attach the property? Section Rule 41 to 57 deals with regards to the modes of attachment of the property. As per the nature of property, mode has been given for the attachment of the. Our next mode is the sale of the property. Section 65 to 67, 65 gives the purchaser's title. Sale general provisions with regards to the sale, who are competent to conduct the sale, how sale has to be made, officer of the court are competent, and sale has to be made by auction, public auction it can be said. What is the sale of movable property and the immovable property? The procedure is one and the same. The sale is required to be conducted by the competent officer of the court by virtue of public auction. If the property is the immovable property, from the date of publication, 15 days time is required to be given, and for the movable property, 7 days time is required to be given. These are the provisions with regards to the sale. If there is more than one person claiming the said distribution of assets, section 73, and the last portion with regards to the resistance to the execution, and rule 97-106 deals with regards to the resistance to the delivery of possession to the decree holder. During the said period, the same court is having power to grant the stay to the execution according to the rule 26 to 29. After, if it is the execution proceeding has been filed after 2 years, then process is required to be given by the court. Process for execution is 24 to 25. So these are the crux or the important aspect deals with regards to the execution of judgment and decree. Thank you.
Thank you, sir. Good evening, everyone. At the outset, I express my sincere gratitude to Sandeep Munde sir for delivering such a clear and insightful session on the execution of decrees and orders provided in the Civil Procedure Code. Sir's structured, practical, and exam-oriented approach has once again transformed a technical subject into something accessible, engaging, and easy to grasp. Sir, despite your demanding schedule, your consistent guidance and commitment to this lecture series are truly invaluable for all the aspirants. You are conducting these sessions with the sole objective that capable and competent judges emerge from among the aspirants. And this noble intention truly inspires all of us. I also extend my heartful appreciation to all the participants for active and disciplined participation. With these words, we conclude today's session. Thank you all for your gracious presence. Good night. Shubharatri.